So we will begin with panel 2, case studies from 4 regions. I'm not going to go through the items that are identified, but we have 4 excellent speakers. As we have had this morning, we will be going to our guest speaker in New Zealand, Aotearoa, with Andrew Erueti, a very distinguished scholar and related very closely to the lady we had on this morning, and she was exceptional. Andrew, you have to hold up the men here. You have to try to do as good or better than Claire Charters. That's a high standard, so the floor is yours, Andrew.
Thank you, Chief. Chief John. Kia ora koutou katoa. Ka nui te mihi nui ki a koutou katoa ki ngā tangata whenua o te Rohe, me ngā rangatira kua hui mai ki te tautoko tēnei kaupapa. So my name is Andrew Erueti, and I'm a lecturer at the University of Auckland, and just recently appointed to the Royal Commission of Inquiry into the treatment of children in state care and faith-based institutions. I just want to check to make sure that everybody's hearing me okay. Is this covered? Okay. And I understand 10 minutes, 15 minutes tops? 10 minutes, great. Okay, so I'll be brief. And I wanted to talk about, focus on the Royal Commission and the role of the UN Declaration on the Rights of Indigenous Peoples and the Treaty in establishing the Commission. But just quickly a brief description of what it is. It's a Royal Commission, which means that it has significant mana or authority. They are the most significant commissions that can be established under New Zealand legislation. And it's the largest Royal Commission that has been established in our history. And its tasks are set out in the terms of reference, which were the final terms of references. Reference was released in November last year. And essentially, we're tasked with inquiring into the treatment of children that have been in the care of, first of all, state-based institutions, but also children that have been in the care of faith-based institutions. The type of abuse we're talking about is broadly defined in terms of reference to include physical, psychological abuse and neglect. And the focus are not just children, but young adults and vulnerable adults. And we're required to investigate the reasons that led to children being taken into state care, how they were treated, and the impact that has had upon the survivors themselves and their families, whānau, and communities. We have to produce 2 reports, an interim reports within 2 years, so the end of next year, and the final report will be due 2 years later. So that's the end of 2022. There are 5 commissioners. The Chief Commissioner is a former Governor General of New Zealand. There's myself. There is a Pacifica barrister, Sandra Alofevai, the former Human Rights Disability Commissioner, and another District Court Judge, Coral Shaw. So we're quite a small team with a very, very large mandate. So the treaty dimension is the reason why I became first involved in the call for the inquiry. So we presently have a Labour-led government, but the prior National-led government had opposed the idea of an independent inquiry. And so my initial involvement was, I led a Waitangi Tribunal claim seeking an urgent hearing, requesting a tribunal inquiry into the need for an independent inquiry. When I became involved, it was very clear that there was a major Indigenous component to this issue. The vast majority of children in care today are Māori. The survivors who have been calling for an independent inquiry are predominantly Māori. The focus initially was on residential institutions that were established in the post-war years. And during the 1960s, 70s, and 80s, these institutions were filled up with Māori children and young adults. There is a clear connection between the institutionalization of Māori children in state care and their subsequent over-representation in the prison system. So Māori today, Māori males, over 50% of those in prison are Māori males. Over 60% of women in New Zealand prisons are Māori women. So it's imperative that we get to the reasons why Māori were absorbed into the state system in such large numbers over those years. The terms of reference direct us to look at those specific questions of institutional racism, of the targeting of specific minorities and Indigenous peoples. And we need to document and investigate the impact that this institutionalization has had on Māori and their communities. So a lot of parallels then with the child welfare policies, the impact on Indigenous communities in Canada and Australia over those years. So we have, it seems quite clear, a similar type of scooping policy that was applied by our child welfare agencies in the 60s and 70s and 80s. And as I said, it remains a serious problem today with the vast majority of children in state care today being Māori. So the Declaration of International Human Rights and Indigenous Rights were critical to getting the Royal Commission established. When I prepared the Waitangi Tribunal plan, we relied a great deal on the Declaration. We prepared submissions to the Racial Discrimination Committee and the UN Human Rights Committee, noting the need for an independent inquiry. We relied upon the Treaty of Waitangi, but we relied on specific provisions in the UN Declaration of the Rights of Indigenous Peoples, specifically the right to free, prior, and informed consent, and the right to a remedy, expedient, access to justice, self-determination. It seems that a golden thread running through child welfare policies in Aotearoa, New Zealand, is that Māori haven't had sufficient autonomy and control over the care, that child welfare policies and laws have been formulated without sufficient engagement with Māori. One of the most striking things for me in this process was that there is a process of reparations, a redress scheme for survivors, but has been strongly criticised by Māori survivors and others for this need to reflect custom, tikanga Māori, customary law, practices. It seems to be largely a process that's operated by lawyers without any formal restorative redress, any, as we call it in Aotearoa, ki te kānui, face-to-face engagement between the Crown and others. But what was most striking was that the process was established without any engagement with Māori at all. It was quite remarkable how this process was established. We have a hopkins ahead of us. I'll just hit on the most salient points given the limited time. The terms of reference refer to the Treaty of Waitangi. But we need to, as a commission, work out how to give meaningful effect to that. It seems that the commission was formally established in November, so we're just very new to this and we're still building the foundations. We need to work out how we're going to gather evidence, whether it's through a truth private meeting process, public hearings. We need to work out what sort of research plan will be developed, including the historical narrative that describes how Māori were absorbed into state care. We need to have a fully developed outreach plan so that we engage fully with affected communities, that specific communities as well, people with abilities, making sure they have fair access, women, LGBTQI community members, but fundamentally the Indigenous component. When the call went out for an independent inquiry, many Māori leaders called for a independent strand related to the commission that was devoted solely to treaty matters. So we need to consider how to give effect to those aspirations. And we need to develop an outreach program so that we fully engage with survivors and their families and communities. One of the key challenges will be the fact that only to state-based institutions, which were largely filled up with Māori children, but also the extension of the mandates include faith-based institutions. So it's extremely broad. And if you look at the faith-based institutions, the survivors, you can see that there seems to be less Māori involved in that cohort of survivors. And there are already some tensions between different survivor groups for that very reason. I think I'm getting close to the end of my 10 minutes. I think I'll wait for questions there, just wrap it up there for now. Kia ora.
Thank you. We will proceed with the other speakers on our list here. We have 3 speakers: Erika, lady to my left, Edtami, and Kristen. So we'll go with the list the way it's put on here. And Erika, you're up. Erika is a member of the Expert Mechanism on the Rights of Indigenous Peoples from Latin America and Caribbean. She's from Brazil, where it's plus 35. In Manitoba, Winnipeg, where it's minus 35. She specializes in addressing international human rights issues of Indigenous peoples at the local level. So, Erika.
Thank you. I would like to start acknowledging that we are meeting on traditional territory of the Treaty 1 peoples and the homeland of the Métis Nation. I am very honored to be here, and I would like to thank the University of Manitoba for the invitation, and also Celeste on behalf of all the other organizers for the very literally warming welcome. I had to borrow boots, hats, coat. I would like to thank the opportunity to be here with Chief Ed, but also with my colleagues Edtami and Kristen, and Alexei, who will speak to you later in another panel. We, as the Expert Mechanism on the Rights of Indigenous People, work as a team. So there are 7 should be 7 of us, and it's an opportunity for the 4 of us to be here, so we'll be also having our own little meetings at night. So it's also an opportunity to support the mechanism in that way. And acknowledge Chief Littlechild, our always member of the expert mechanism, always part of our team, and I am very lucky to have been able to join him at the mechanism. The mechanism is a subsidiary body to the Human Rights Council. It's composed of 7 independent members, 1 from each of the 7 indigenous social cultural regions. We do not represent indigenous peoples from our regions, but we come with our personal expertise from each of the regions to contribute to the Human Rights Council. I myself am not an indigenous person, so I feel very fortunate to be working with indigenous experts. But I have dedicated the last 15 years of my career in Brazil working for and with indigenous peoples, indigenous organizations in Brazil. In 2016, the Human Rights Council, following an outcome recommendation from the First World Indigenous Rights Conference, amended the mandate of the expert mechanism to provide the Human Rights Council expertise in advices on the rights set in the UN Declaration on the Rights of Indigenous Peoples, but also to assist member states and indigenous peoples upon request in achieving the ends of the declaration. That includes offering technical assistance and dialogue facilitation, always upon request, and with a view of the implementation of the declaration. In those discussions, many of the states said, we already have too many monitoring bodies, and we already received too many recommendations on how to improve or protect human rights for indigenous peoples. So we wouldn't want another extra body, a monitoring body. And the discussion developed so that MRIP could work to provide technical assistance for concrete cases and concrete actions where we could advance in the implementation of the declaration. So we have been doing country engagement missions, and we also continue to undertake regular thematic studies where we provide analysis on specific rights of the declaration. Our latest report study was on FPIC, free, prior, and informed consent, and it's online, it's available. We have presented it in our last session. And the current study we are working on is on migration, borders, and displacement. So we are still open to receive contributions. You can send it to the expert mechanism at ohchr.org. It can be experiences from indigenous peoples, indigenous organizations, in cases that can highlight challenges and good practices, and even the whole discussions of concepts of what is displacement, what are borders, what is migration for indigenous people, and the human rights context of all of it. But I prepared to bring a case, and I thought I'd bring a case study from Brazil. So should I just press this? Okay. And as you know, in Brazil, we are living a very critical context of regression in the whole agenda for human rights, but mostly with regard to indigenous peoples, human rights, and particularly land rights. And therefore, I decided to bring the case of the Yanomami people from Brazil, as it illustrates the relationship between national and international laws, but also national and international contexts, and its impacts on indigenous peoples and their rights, and particularly the right to land. It also shows the challenges that indigenous people continuously face dealing with colonizers, old systems, and old views. I prepared this just last minute because when I arrived here and it was so cold and so different from where I was, I thought I might bring some pictures because it's hard to imagine. So I hope it can help to illustrate. The Yanomami is a society of mainly hunting and harvesting people living in the Amazon forest, both in Brazil and in Venezuela. Its population in 2011 was estimated to be of near 35,000 people, being the majority of this population in the Brazilian side of their territory. For the Brazilian government, they have been considered a group of recent contact, and therefore policies towards the protection of their territories has been considered of utmost importance. The Yanomami territory is also home for a few groups of indigenous people living in volunteer isolation. Just so you know, in Brazil, the government recognized 26 indigenous groups or peoples that live in volunteer isolation, and we have information of over 100 other groups that live in the same situation in the Amazon region. And the policy has been of protection, but without forced contact. So I would like today to focus, on the history of the indigenous land demarcation, defined by the presidential ratification in 1992 of an area over about 96,000 square kilometers, which is called the Yanomami indigenous land. This story could be told in many different ways, with different approaches, including through the most refined spiritual explanation of what is Yanomami land and how the land and the people sustain the world, actually sustain the sky not to fall on our heads. And for that, I suggest the book from Davi Kopenawa, the Yanomami world famous non-leader. He's written this beautiful book explaining how the Yanomami people and the Yanomami land are holding the sky not to fall on our heads, with beautiful drawings and explanations from the spiritual point of view, but also from the relationships that the Yanomami people have maintained with governments and international partners, and the whole story of the Yanomami people. It's in English and Spanish, in Italian, in French, so it's available for all of you. I'll try to tell you a little bit on how the advocacy of indigenous people around the demarcation of this land has changed law and policies in Brazil, and its relationship with international law and campaigns. The case also helps us to understand the current challenges faced by indigenous people at this very moment in Brazil, and it shows that above all laws and standards, for indigenous peoples, human rights is about resilience and resistance. So why is the Yanomami a landmark case? It was the first case of indigenous rights to land brought to the Inter-American system. Let me see if I can do this. So it was the first case regarding indigenous lands and indigenous rights brought to the Inter-American system against Brazil, and that was in the year 1985. So the case contributed to the significant change in the Brazilian Constitution, which is from 1988, where for the first time indigenous lands was recognized in a broader manner, which I will explain in a second. It has also received international attention, including during the military dictatorship that we had in Brazil, and that has been crucial for the struggles of the Yanomami people. The Yanomami case has also got the first and only sentence of conviction for genocide in Brazil. That was in the year 1997, due to the massacre of the known as the massacre of Hashimu, which happened in 1993. And it continues to be mentioned and threatened because it's a symbol of the recognition of indigenous people's rights based in a human rights approach in Brazil. The Yanomami continue to suffer attacks, invasion, and impunity, showing that formal recognition and mere demarcation of lands are not enough when indigenous peoples are not entitled to have its autonomy re-established, as they continue to dedicate a great part of their lives just for fighting against illegal mining, diseases brought by illegal miners, and attacks at the national political level from the part of very powerful class of politicians that never leave power. In a very summarized manner, what the case reveals is how difficult it is for countries like Brazil to advance in the recognition of collective land rights, cultural diversity, and moreover, indigenous autonomy. I mean, countries where inequality and concentration of lands go hands in hand with concentration of power, and where agrarian reforms have never been completely faced by any government that we had, much less the process of true reparation and reconciliation with indigenous peoples. From the legal point of view, the nature of land rights, if much, has historically been defined in Brazil only through its civil rights aspect of the right to property. Colonial views are predominant in all of the state branches. For a long time, the state adopted assimilationist policies towards indigenous peoples, and reservations would be created only as temporary small plots of lands, aldeias, or reservas, in expectation that indigenous peoples and cultures would fade away or be integrated or lost by to the dominant society. Because of such loss, indigenous identity has never been, but indigenous loss of identity has never been a reality in Brazil. And they have resisted against such policies, and therefore in 1988, the state reviewed its constitution, and the views towards indigenous people has completely shifted at least in the formal way, in the constitution text. So the 1988 Democratic Constitution of Brazil recognized indigenous people's rights and incorporated social cultural aspects in the definition of what is an indigenous land in order to guarantee indigenous people's continuity and to respect their cultural diversity. The constitutional text defined indigenous lands as lands traditionally occupied by indigenous people, but also as lands used for their productive activity, welfare, and necessary for the cultural and physical reproduction and survival according to indigenous people's own uses, customs, and traditions. But although since 1988, the right to land for indigenous people is recognized in the Constitution, as well as the duty of the state to demarcate and protect those lands, only in the past decades, Brazil has been able to address economic, social, cultural, political aspects related to the rights to lands for indigenous people, and with a lot of limitation through processes of demarcation by the executive branch. And those processes has never been finished. There are over 150 indigenous lands awaiting demarcation procedures to be finished by the executive branch. Also, no reference to standards, commitments, or obligations under international law can be found in relation to those few cases that have reached end. Our Supreme Court has over 100 cases to be judged It's more than 100 pending cases on land rights for indigenous people. And in my research that I did up to 2009, there has never been a reference to ILO 169, much less UN Declaration, OAS Declaration, or even international human rights instruments. Up to today, the Supreme Court of Brazil has not been able to define the right to land for indigenous people as a human right, as a fundamental right. It's always through the civil right to property approach. And I must say that outside the UN Human Rights Council room, or even so, we never hear Brazilian state authorities make any reference to the declaration. So the 1988 constitutional new paradigm and the whole idea of demarcating corresponding indigenous traditional lands continue to be considered a new and very challenging idea. And the Yanomami case illustrates it. I forgot to keep showing the pictures. Yeah, that was to show a little bit their housing and women's cultural activities, and that's during celebration of the demarcation of the lands. And their houses can be really big, up to live with 300, from 100 to 300 people living in one house. That's one of the examples. So I was talking about how the Yanomami case is significant, and it has influenced the constitutional process of making it. The Yanomami claim for demarcation arose after several deaths were caused by the presence of intruders in their lands. The case was brought to the attention of the international community and taken to the Inter-American Commission on Human Rights in 1985, and then the state received recommendation to protect the lives and territories of the Yanomami. So a few years later, in 1991, the Yanomami land was demarcated in Roraima state to meet the physical, social, and cultural needs of indigenous peoples from the area. The next year, the state's political commitment to protect indigenous peoples' lands and human rights were reaffirmed during Earth Summit Rio 92. By then, it was found that near 2,000 Yanomami had died between the 1980 and 1990 due to the spread of disease or shot by intruders in their territories. I think I have some pictures. So the demarcation was celebrated with a lot of hope for change and to the fate of the Yanomami, but also to really establish new standards for other indigenous peoples that are awaiting demarcation of their lands. The Yanomami land is the territory for at least 4 peoples of the same linguistic family, the Yanomai, Yanomami, the Sanuma, and the Nima, and also of the Yekuana people. This unification was a strategy to guarantee that the territory of those peoples, including commonly used areas, would not be dismantled into islands within the territory. That was the idea of the government. It was a landmark that the Yanomami land was recognized as a continuous territory for those people, considering their relationship and traditional use of those lands. But even as a contiguous territory and demarcated territory, indigenous people in the Yanomami land still face immense challenges to protect their lands against invaders, including or mostly illegal miners for gold, loggers, and hunters. So demarcation and formal recognition alone is not enough. In 2011, it was found that more than 1,500 illegal miners were inside the indigenous land, which is forbidden in Brazil, and the state was denounced by its omission. In 2017, the Special Rapporteur, Victoria Corpus, took note on this and addressed the situation on her report. Several media sources reported on this as well. And a couple of years later, academic researchers showed that in some communities, 90% of the population is contaminated by mercury, commonly used in gold mining activities. So the pressure for deforestation and invasions continue and is promised to increase in the Yanomami land, but also all over the country. And it will have an even worse impact on indigenous land that haven't been demarcated or they are threatened to be divided in small islands. And this is the low standard to which the majority of Congress now and our new president are promising to bring back. In at least 2 occasions, the new president affirmed that he would review the Yanomami land's demarcation to diminish it. At the first hours of this new government, on the 1st of January, the president took severe measures, sending the message that indigenous lands demarcation will no longer proceed. Amendments to the Constitution, the dismantlement of policies and institutions, the denial of collective rights and the right to cultural identity, the denial of indigenous autonomy, along with the disregard to the most advances that we have managed to reach in the environmental law and policy protections are already taking place in Brazil. Of course, those are all with disregard to the UN Declaration, to obligations under ILO, CERD, ICCPR, and so many other human rights and environmental instruments to which Brazil have signed. And those initiatives also shake the world's future for human beings. I'm sorry, I forgot to show those pictures. Those are the reminiscents, the ones 22 Yanomami that were able to escape from the Hashimu massacre in 1993. And so what I bring here is the inevitable question of what is the real purpose of law in the context where indigenous people are not fairly represented in the political system. And you know, to bring a little bit of how indigenous peoples are facing and resisting a new era or a go-back era of attacks, because we are talking about going back 30 years in legislation, in policies, and in the threats of lives of indigenous people. Particularly in the case of the Yanomami, there has been almost 30 years of documentation and monitoring by international human rights body. There is a long relationship built of Yanomami leaders with international authorities, with stars and singers, world famous, as well with NGOs and indigenous movements, which should and can be strengthened. And also the possibility of Yanomami association to access UN and UN mechanism is also highlighted as an important aspect of this case. So in 2017, the Yanomami Association submitted a shadow report to the Brazilian Universal Periodic Review, and along with other indigenous reports, it triggered 32 recommendations to the government related to indigenous peoples' human rights and including the right to land. So right now, indigenous peoples from Brazil, including the Yanomami, are calling for further international solidarity and support. Visibility as well as international pressure may play its role again, just like it did in the late 80s. On the 30th of January, there will be a general call from an indigenous movement in Brazil, and you can all join from any part of the world. There is going to be a lot of media, Twitter, Facebook, Instagram campaign to support indigenous people's rights. So that was just about it. And I finished, well, there was a link to Davi Yanomami, some words, but we don't need to put it now, and I can send it to you. And some pictures from this photographer that has been working with the Yanomami for 30 years. And the exhibit is in one of the most famous galleries in São Paulo. So you see one of the Yanomami watching the exhibit of pictures. And I thought I'd bring some of her beautiful pictures because I also think through art and, you know, reaching the heart of the people is how we will manage to continue to contribute to indigenous peoples, to human rights, and to diversity, but also to our own possibility of living in a better and beautiful country and world. Thank you.
Thank you, Erika. That's, I think that story's in the media in this country for sure, with the new president and the steps that he's taken with respect to what you were describing at the end. So really very important, useful background information and context for us to understand these short media clips that we see here. I'd like to, Edtami, go to you now. Edtami is also a member of MRIP from Asia, the chair of the interim governing council of the okay, I'm going to leave it to you to say that one now. English is, the English letters, they really mess up languages. English is backwards to my language, so when I think in English, I think backwards. Because my language is the other way, my indigenous language. So please, oh, you have a microphone there, so.
Yeah. Thank you. Good afternoon. I don't have something to show, and I can just imagine that we have decent pictures with Erika, because Philippines is also a tropical country. I experienced the same, you know. Actually, I enjoyed this cold temperature here because my friends back in the Philippines cannot imagine how it is to survive in a minus 40, minus 27 temperature. But I'm really very glad and very honored to be part of this very significant gathering. First, I would like to acknowledge and express appreciation, and I feel that I am welcome with the welcoming rites conducted by the elders. As indigenous person, I understand the indigenous spirituality, the special connection of indigenous peoples to their land, that, you know, that intergenerational responsibility to relate with the spirits, that deep understanding of the environment, and it cannot be expressed maybe in English language. That's why the 1919 as International Indigenous Language is very important, because if we lose our language as indigenous peoples, we will also lose those kind of understanding, you know, how we relate to our environment. So in our tradition, we have this belief that leaders or speakers of the tribe have their own guardian spirits. We call them Tagulambong Pandaag. And as I face this very special audience, the academe, I hope that spirit is somehow with me, because I am not really good in, you know, doing case studies. The moment I received the invitation and I was asked to prepare a case study on civil and political rights for Asia, I've been reading, I've been surfing in the internet, and sometimes it make me wake up in the middle of the night just to imagine how should I present. But I am glad that aside from the academic intent of this gathering, it is also a gathering for indigenous people. And it is where I found my strength as indigenous person, rather than presenting the way it should be as an academic study. I decided to relate my own story from our own struggle in Philippines, particularly in Mindanao. I have a burden. No, not really a burden. Of course, it's a honor and responsibility to represent Asia. But Asian indigenous people is very diverse. Like any other countries, we suffered and we continue to suffer the consequence of colonization, the policy of integrationist and assimilationist policy, where the colonizers always prescribe and always seem to see that there should be something changed. Something must be done for the indigenous people. And in the Philippines, sometimes it's done in the name of religion, in the name of education. That's why I understand why children has to be separated from their parents, because they have to be educated. And they call this civilization. But we have, they cannot understand that indigenous peoples have already their own far more advanced civilization. So when I reflect on the idea of how can we protect the civil and political rights of the indigenous peoples in the states, especially in the context of Asia, it's a big question, because particularly as what I've experienced at the expert mechanism, Asian states are not very receptive, or they are not participating in the process actually at the expert mechanism meeting. All over Asia, even those states that are not formally colonized, such as Thailand, Nepal, they still regard the policy towards indigenous peoples are the same. So the situation of indigenous peoples all over Asia, I think is almost the same with each other, facing dire poverty, difficulties, cannot relate, cannot engage with the states, especially when other official languages are imposed. So in the Philippines, this is only the country that we have passed domestic law, which is called Indigenous Peoples' Rights Act in 1997. Indigenous Peoples' Rights Act is, recognize the rights of the indigenous peoples to the land. We call that ancestral domain and ancestral lands. So it created the commission, a national commission for indigenous peoples, wherein I was, incidentally, I become part of that first and second commission. I was the only commissioner in that time that was reappointed, because we were given 3 terms, a 3-year term with eligible appointment of another term. So all in all, we have 6 years. So the function of the commission is to create policy. It has also quasi-judicial function, and particularly to recognize ancestral domains. Now we already have 5 million hectares titled as ancestral domain, awarded with that title. It's actually a recognition by the state that before the existence of the state, there is already indigenous peoples based on the concept of native title, meaning that the acknowledgement that indigenous peoples have their own land before the Philippine government is established, and we invoke that. But ancestral domain cannot be sold. It's a collective ownership of the community. But even that, even the implementation after it was 1997, so it's more than 97, 2007, 20 years. There is, I feel, being a part of the first and second commission, that the recognition of the right of the indigenous people is not yet fulfilled. We are not yet there, as the earlier speakers this morning have. It's a continuing contest, a continuing effort. Personally, I still feel that there is no appropriate recognition yet given to the indigenous peoples. That the states still have that idea that indigenous peoples are just cultural communities and they are good for cultural performance, and that they have leisure as economic communities or as political communities. So they just become decorations while their lands are taken away. So with the start of the implementation of the Indigenous Peoples' Rights Act, ancestral domains were delineated, but there is a gap, I think, because it did not recognize the whole territory of the tribe. That's why Lumad Mindanao People's Federation, our organization in Mindanao, composed of 33 indigenous peoples, 33 nations. This is the 64% of the indigenous populations in the Philippines is located. We design a framework to, how to express the right to self-determination in the context of the Philippines with the existence of the law. So we emphasized one tribe, one territory, one governance. Meaning, we have to go back to our indigenous political structures. We have to strengthen that. Because we know in Mindanao, its people, its tribe, exactly knew their traditional boundary with the next tribe. And every river, every mountain, every place within the traditional territories are named after their own language is actually a living pages of their history as people. But of course, just like other colonized places, the name of the rivers, the mountains, especially places, are changed because sometimes they cannot pronounce. They have the difficulty. The colonizers, the invaders have the difficulty. But in 2004 actually, we have our own all leaders summit on territorial governance. We look back of what had happened in our organizing work for 2 decades, because we were very busy after the downfall of the dictator Marcos. We were very busy organizing communities based on issues, projecting issues, militarization, development aggressions such as dam, big plantations. And in this case, we realized that we are not really organizing our people. We are further dividing them. So in the context of asserting our right to self-determination, it is very important to be very clear what is that collective self. So we have to go back, we have to learn, we have to, because this is the only way where we can stand up, because we feel in, lobbying with the government that the government is not really responding. And when we feel that if the government is not effective for us, we have to establish our own government. And we are trying somehow to coexist, but we have to build our own strength from our own people. There are political changes, conditions, especially in Mindanao, because we were organized by, we call that support group, church groups, cause-oriented groups, before NGOs, and we started from there. Then we find the need to evolve that into people's governance, and now we have that concept, and we are working on that, and we are redefining, our governance structure based on our territory, based on what we remember as the structure of our governance. So we are towards that direction, I think, and the challenge for us is, to support how we can stand on our own feet as people, because I think even NGOs, even government cannot provide what they need. Right to self-determination is meaningless if we rely support from others. We have to make our territories productive, and that is the big challenge that we face today. And I'm really interested to listen to experiences here and observe, like First Nations, how they are doing that. This morning I already hear some points on this perspective. Thank you, and maybe we can further discuss on this.
Thank you. In the network of the complexities in that whole South Asia region, that there is, there's a lot of complications, including that many states still don't recognize that indigenous peoples exist. And with the example, I think the challenges that you're talking about are really many challenges that we see here in Canada as well now with the new national government, well, previous governments as well, but there are greater degree of arrangements and flexibility. This morning I talked about Indigenous sovereignty, the pre-existing, as our Supreme Court of Canada said, pre-existing Aboriginal sovereignty reconciled with assumed Crown sovereignty. And so our next speaker, Kristen, will be absolutely familiar with these concepts. Kristen's at the American Indian Law Program at the University of Colorado. That's where I believe that our colleague James Anaya is the Dean of Law. That she is a member or president of the Federal Bar Association section on Indian law. And thank you for accepting the invitation. So she's a member of MRIP as well. Kristen, the floor is yours.
Thank you. Thanks so much for having me today. I appreciate being here in the 2019 spirit of the International Year of Indigenous Languages. I think we're all trying to commit to speaking our or other Indigenous languages. So I also want to say Osio Tohiju, Dagodoa Kristen Carpenter, Gale Liga Wado. Thank you to all of our hosts and friends who have welcomed us here, and especially in my case and others, clothed me with warm things when my luggage didn't arrive. And also thank you to my colleagues with whom I always enjoy very much working, and we're deeply committed as a group, and I love the fact that we're a collegial mechanism to making a difference with respect to realizing the aims of the Declaration, which is our mandate. Along those lines, I am presenting a pretty specific case study growing out of the North American region, which is where my MRIP appointment comes from, and it has to do with sacred sites and human rights. And as a practicing lawyer, a lot of my legal work has been representing American Indian tribes in sacred sites claims involving their religious freedoms. And also quite a bit of my academic work has been researching the property law and religious freedoms law aspect of these cases. And I offer this case study as an example of a realm of the law that in the United States and Canada too, as far as I understand, is in deep need of legal reform, and where implementing the Declaration offers a great deal of promise for a better approach to these issues. This audience knows that for many Indigenous peoples, places on the physical landscape are imbued with meaning, and for some groups it's their place of creation, where they received their identity as a particular people. For others, it's where they interact with the Creator, with the sacred, or continue to engage in ceremonies today. They're places of homeland, of ceremony, of culture, of governance, subsistence, and in many cases give rise to understandings about how to live in the world today as human beings, as communities, and as cultures. One example that is well known to those of you who are from the United States and maybe to others has to do with the San Francisco Peaks in Arizona in the US. And this is a mountain or set of peaks that is sacred to most of the tribes in the Southwest. In the litigation over the peaks, 12 tribes were parties, of whom the Navajo and Hopi are particularly well known. And in the worldviews, the cosmologies of these people, these mountains are constituent elements of their landscape, their identity, their religion, and their peoplehood. Just two representations of traditional customary law on the San Francisco Peaks. For the Navajo, for whom Tokoslid is the westernmost mountain of their 4 sacred peaks, this is one of the defining elements of the geography of their territory. It's also the place where one of their female deities, Changing Woman, went to prepare to give birth to 2 of the ancestors of the Navajo people. It's a place where they continue to direct prayers today, to gather medicines for blessing way ceremonies. It has deep, deep significance in what it means to be Navajo today. For the Hopi, you can see too, this is a representation of a petroglyph. The peaks offer a slightly different role, but they're the place where the Kachina, the people, the beings who bring rain to the Hopi people, go to gather water during the winter, and then they come back to the villages in the spring to nurture the corn and the crops. And this is the time when the dances come back to the village, and an entire life cycle of the Hopi people is dependent on protecting the peaks as a place where water and the Kachinas come from. And so I'm offering this as an example because it's an important in its own right, but it's also representative of the experience of so many Indigenous peoples in North America, certainly in the United States, where a mountain, which may in other cultures have an inanimate kind of existence, is by contrast living, and it's deeply embedded in the identity, the survival, and the future of the people. The challenging thing from a legal perspective for contemporary American Indians in particular is that often their sacred sites through the process of conquest and colonization are now located outside of their jurisdiction, outside of tribal lands, and so off the reservation or the reserve. And this is a representation that's actually on the Navajo Nation's flag of the Navajo Nation's reservation lands. That's kind of the darker tan color. And then you see the 4 sacred mountains. Oh, I'm sorry. Which one am I on? Okay, sacred lands, instructions for living in the world in a good way. San Francisco Peaks, thank you, Daly, for saving me. This is a very, very beautiful mountain range. I'm advancing my own slides, which are just great. Okay, so here we are, San Francisco Peaks, super sacred, Navajo worldview, you got it, Hopi worldview, as represented on a petroglyph. Everybody up to speed? Okay, great. Moving right along. So everything was great, and then there was colonization, and now the sacred sites are outside of the reservation. And so the problem with this, and this dark tan stuff, is the reservation. So you see in the west, the peak represented as the yellow peak. That's the San Francisco Peaks. I'm going back. And for the Navajo people, that's their western mountain. And they, as I was saying, offer prayers in that direction. They require it to be a healthy, living mountain to nurture plants, certain plants for gathering, to take care of the deities who live there. It's critical to their well-being, their identity, their prayers. But it's now located outside of the reservation. And not just that, but the United States, the federal government, owns it by virtue of having established the boundaries of the Treaty of 1868 to exclude the Navajo Nation's sacred sites. And this is pretty much just a pattern in the United States. Indigenous peoples' most sacred sites are outside of their jurisdiction. And so in this case, as in many others, the United States wishes to use this sacred site for purposes that are at odds with the American Indian spirituality. And so in this case, the U.S. Forest Service licensed a corporation which owns a ski resort to do snowmaking on the mountain using reclaimed wastewater, treated sewage effluent. And for the Navajo people, first of all, the water is sacred, and the mountain is not supposed to be desecrated. And in particular, water that has human waste is a particular desecration for them, even if by contemporary water quality standards it may be non-potable but useful for certain purposes. So the Navajo Nation, along with the Hopi tribe and every other tribe in the Southwest, and basically every Indian lawyer in the country, got involved in this case to stop the Forest Service from allowing the snowmaking to go forward. And the action filed was under the First Amendment. And of course, as many of you know, the United States was founded on the basis of religious freedom, right? To allow people with divergent religious views to enjoy the ability to worship their own gods and practice their own religions. And unfortunately, however, it has turned out that the protections of the First Amendment do not apply to American Indians in the United States. And in so 2 lines of cases, one involving sacred sites, one involving peyote, the Supreme Court has held that the federal government can destroy an American Indian sacred site, even if it will virtually destroy the American Indian religion. And secondly, that state governments can prevent people from participating in American Indian sacraments, like peyote sacrament, because it's a controlled substance. This holding, so the basic thing is the federal government can destroy American Indian sacred sites without running afoul of the First Amendment, which we otherwise hold very sacred, was essentially the holding in the Navajo Nation case. And it was applied even to this new statute, the Religious Freedom Restoration Act, that is supposed to reify and expand religious freedoms in cases like this. This example, of course, in the United States is not exclusive to the United States. And although I know the case less well, I understand that in BC, here in Canada, Grizzly Bear Mountain, which is home to the bear and the bear spirit, has been similarly authorized for development as a ski area. And also similar, a factor that I didn't mention in the San Francisco Peaks case, is that there was actually consultation with the relevant indigenous peoples who, of course, voiced their opposition to development of the ski area because the people were entrusted to take care of the mountain. And the court held here that the BC government had engaged in deep consultation, thereby meeting its duty to consult and accommodate under the relevant law, Section 35 of the Constitution Act. But this law didn't give the indigenous people the right to terminate the project. It guarantees a process, but not a particular outcome, and not a particular outcome that would honor the views of the indigenous people. Now, this is the same exact standard as we have in the United States. We have all of this law about consultation. Tribes get to consult. And so the Navajo Nation told the Forest Service, no, if you use treated sewage water on our mountain, that's going to impede our ability to practice our religion. And the courts held there too that just that process of consultation, of listening to the Navajo Nation, that was enough, even if the Forest Service decides to do exactly what the Navajo Nation asked it not to. Here's the result, unfortunately, in the Canada case, and this always strikes me as adding insult to injury, because I think that grizzly bear has been used as a marketing tool for this ski area when it has a sacred element to the people. So these examples are not isolated. In North America, they're everywhere because, of course, lands are a very valuable resource, and many private owners, as well as the United States, seek to develop them. I'm at 11 minutes, and I'm going to try to wrap this up in 3 minutes. The problem, as I said, in the United States is that the law, the domestic law as it exists, just simply has not been interpreted to protect American Indian religious freedoms. Now, it should be. Of course, it's the case that if the First Amendment protects the free exercise of religion, that should include American Indian religions as a matter of non-discrimination, as a matter of equality, and as a matter of freedom. But the Supreme Court has repeatedly held, no, the First Amendment does not apply to protect American Indian religious freedoms. No, the Fifth Amendment does not apply to protect American Indian lands. So that's where we're starting from. And as I mentioned, the consultation requirement is only that of consultation. It doesn't require consent on the part of the indigenous peoples. So my sort of the crux of the argument here is that that's not satisfactory. You cannot represent American Indian tribal clients and say the end of the road is that the federal government has the right to destroy your sacred site, because of course indigenous people's own laws and customs require them to protect those sites. So they're seeking additional remedies. The UN Declaration on the Rights of Indigenous Peoples has quite a few provisions, and I'll just mention 4 that are directly relevant. So of course in Article 11, indigenous peoples have the right to practice their religions. Oh, thank you, I will advance. Problems with sacred sites everywhere. Law in the United States is really bad. Okay, Article 11. So Article 11, I'm just going to mention 4 articles. So indigenous peoples have the right to practice their spiritual ceremonies and so on. We don't have that in the United States. Second, Article 19, right? States have an obligation to consult with indigenous peoples in order to obtain their free, prior, and informed consent before adopting legislative matters that affect them. That should apply in the realm of sacred sites as well. So if somebody has a great idea to develop a ski area on public lands that affect American Indians, they should have to obtain their free, prior, and informed consent. Article 25, indigenous peoples have the right to maintain their spiritual relationship with lands, even if they don't currently own those lands. And Article 28, that indigenous peoples have the right to redress lands that were taken from them, including spiritually significant lands. So to pull this all together, the goal for so many of us in so many contexts, I think, is to reform domestic law consistent with the Declaration and with international human rights law generally. And we have a project at the University of Colorado with the Native American Rights Fund that's trying to think about how to do that in a broad-based way in the United States. And my sacred sites example is one case study. So a few ideas. One, we should argue in the courts to interpret the First Amendment consistent with Articles 11 and 25. So if we're saying there's religious freedom in the United States, what that means in the Indigenous context includes a right to access spiritually significant lands and to engage in spiritual practices. That's the way the First Amendment must be interpreted. We actually have precedent in the United States interpreting the Eighth Amendment's prohibitions on cruel and unusual punishment vis-a-vis juveniles consistent with international human rights law. I think we could use that interpretive methodology vis-a-vis the First Amendment. There's a recent case that suggests some movement there. That's an argument for the courts, perhaps, and the Constitution. When it comes to Congress and the agencies, I'm hoping that we could push for administration of American Indian sacred sites consistent with the norm of FPIC. MRIP has been deeply involved in articulating best practices under FPIC in our recent report that Erika mentioned. And there are some agencies in the United States that have started to use the Declaration as a set of best practices in their land management and to negotiate with tribes regarding land use agreements. This is a great model, and it's a much better model than just listening to a tribe and then doing exactly what the tribe asked the government not to. Finally, and this seems radical, at least in the United States, but it is possible and important to prioritize actual restitution of lands that have spiritual value to American Indians and other sacred places. The classic example in the United States was the 1970s restitution of Taos Pueblo, of Blue Lake to the Taos Pueblo. There are other more recent examples too, and I gather there was legislation introduced yesterday or today regarding the Apache sacred lands in Arizona. There are other models where co-management is being used to try to afford American Indians some rights to participate in the stewardship of spiritually significant lands. And I'm hopeful that those too will help to effectuate the norms of the Declaration in the religious freedoms context. I often write with my Potawatomi co-author. If she were here, she would say Jaganenan. In Cherokee, we would say Wado. But thank you all for listening.
Really appreciate the presentation, Kristen. I'm thinking we recently in late fall had introduced into the legislature in the province a new environmental legislation, environmental assessment bill that includes the entire declaration provisions. And here we had pushed to include the free, prior, informed consent in the declaration, Article 32, and the wording directly from the declaration. And there's a lot of questions about, well, you know, the Supreme Court of Canada says you don't have a veto. The best you can do is consult. So we worked out what we called through the UN in Geneva about this notion of constructive ambiguity in drafting. And what we did was we didn't make it really clear about free, prior, and informed consent directly, but what we added into the purpose section of was the implementation of the entire UN Declaration of the Rights of Indigenous Peoples. And there are 20 provisions, at least 20 provisions that deal with free, prior, and informed consent threaded through the entire declaration. So now, if it goes to court, maybe we'll have a different result. I mean, we have governments in this country that seem to be open to well, they're both governments at the national level and at the provincial level where I come from. I've said we adopt the declaration, we will work with you to implement the declaration. There is a national bill that's been approved by the House and before the Senate now on the adoption of the UN Declaration in this country. In our province, the province is committed to legislation to adopt the declaration. So we're in the early stages drafting legislation there as well. And so the whole thinking is that we do it through, it's strange because we've been involved in negotiations for years. We've run into stiff policy walls. So we've had to go to the international level, and we find a political moment when we have governments that we've been talking with over all the years when they're in opposition and all of a sudden they're in power, and we come back to them and say, you committed to this, and of course, lo and behold, we're in a different kind of legal and political landscape. So we're now moving on the legislative front, on the negotiations front to change policies, practice standards to ensure that they're consistent with what we see in the declaration. There's still a wall of bureaucratic resistance, a residual wall, if I would call it that. But it's, I think it's before the declaration was adopted in this country, we worked very actively with governments, those in power and those in opposition to get them to understand it. So it was an easy bridge to cross when these opposition parties became the political in power. But in your case, now you have a government that's going the other way, breaking down agreements that they've made, and yours as well. I mean, how many walls are you going to build? I mean, our wall up here is, I don't know, we might help you build a wall to keep the, and of course, in your instance about native title, I mean, we were faced with in all instances, I think native title is a conceptual construct created by the U.S., pretty much by the U.S. Supreme Court in the Marshall Trilogy, where it finds its first iteration in those judgments. And that's why I raised the question this morning, two things. One, as we push back the colonial constructs, how do we now look at Indigenous sovereignty? How do we build that into legislation? The courts have, in this country, haven't been shy to use the words. How do we build it into agreements? In the case of the Haida peoples in the West Coast, it's in the preamble of their agreement. Haida sovereignty, dealing with forestry matters, and Crown sovereignty. And the courts haven't had to tackle it yet directly here in this country, but I'm thinking that this is an area that will be ripe for litigation in a decade, maybe, or two. I mean, these are not short-term things, they're longer-term things. And so it's taken us 400 years, 500 years in the Americas to get to where we are now. We may take, hopefully lay some groundwork for the next 500 years to roll back some of it, or a lot of the, I hope it doesn't take that long. I mean, I'm not going to be alive that long. My spirit will be, and it's always going to be on this land. But anyways, I wanted to say really from the bottom of my heart, thank you.